Good afternoon, ladies and gentlemen. My name is Jan Wagner, and I am a fourth-year law student at the University of Warsaw. My today's presentation will concern the transboundary provision of health services in the EU. It aims to explain how the Member States, the Commission, and the Court of Justice are trying to find a balance between the rights of patients and the stability of national healthcare systems. Health services play a special role in each human society. In ancient Egypt, the discovery of evidence of healthcare provided to injured constructors of the pyramids led to a significant shift in our way of thinking about their life conditions. It disproved the theory that those structures were built mainly by mistreated slaves. Also today, providing appropriate healthcare is one of the main obligations of states towards their citizens necessary to comply with the right to life and human dignity. Because of that, each EU member state has its healthcare scheme together with its extensive legal regulation. At the core of those systems lay common values such as universality, equity, solidarity, and social cohesion. Nevertheless, their interpretation differs significantly in particular member states, and as a result, the states allocate different amount of resources to healthcare, and also the sources of its financing differ. That leads to differences in the quality, effectiveness, and accessibility of healthcare in the EU. So at this point, there arises the most important question in the field of transboundary healthcare in the EU. To what extent should EU citizens be entitled to seek potentially faster, better quality, and cheaper healthcare in other member states? At the onset, the European communities were not established with the aim of organizing cooperation between member states in the field of social protection. Nevertheless, over time, it became clear that access to healthcare in other member states might be necessary to allow an effective use of other rights guaranteed within the communities, especially the free movement of persons. It would be impossible to move freely between member states if people exercising this right would be required to come back to the member state of insurance to obtain health services. The first regulation addressing this problem was issued in the early 70s and later repealed in 2004 by Regulation 883/2004 on the coordination of social security systems. Although healthcare benefits are outside the scope of coordination provided for in that regulation, it guarantees two important rights to insured persons moving to other member states. Firstly, the right to obtain unplanned treatment that becomes necessary with respect to the current state of health and the planned state in the host member state. Its role is to protect the person in question from being forced to shorten their stay in another member state. In such a situation, an insured person is allowed to obtain the treatment as if they were insured under the regulation of the member state of stay. That right is confirmed by a well-known to all of us European health insurance card. Secondly, the regulation in question provides also for the right to obtain planned treatment in another member state. If such treatment cannot be given in the member state of insurance within the medically justifiable time, the insured person has the right to get the authorization to travel with the purpose of receiving health services abroad in the public healthcare system. Unfortunately, this mechanism is quite ineffective due to the complex procedures of getting the authorization and the interpretation of the time that can be considered as medically justifiable. In its judgment in the case of Watts, the Court of Justice clearly stated that to fulfill this criterion, it's not enough that the same or equally effective treatment is available more quickly in another member state. So as we can see, the access to planned cross-border treatment under Regulation 883/2004 was and still is quite narrow. However, any attempts to broaden it had to be balanced with the exclusive competence of the member states to define their health policies and decide on the organization of their healthcare systems. Nevertheless, the Court of Justice has found a way to bypass that discretion of member states and develop the right to obtain transboundary healthcare provided by both public and private providers via the freedom to provide services. In the first two judgments, Luisi and Carbone and Gorgan, the Court of Justice suggested that health services should fall within the scope of the freedom to provide services. That observation constituted an introduction to a breakthrough that happened as a result of the judgment in the case of Kohl. The dispute in this case emerged after the Luxembourg Health Insurance Fund refused an authorization for Mr. Kohl's daughter to be treated by an orthodontist in Germany. Despite that, Mr. Kohl decided to pay for the daughter's treatment in Germany and later claim reimbursement from the competent health insurance fund. The CJEU stated that the obligation to obtain prior authorization to get reimbursement of the costs of health care incurred in another member state constitutes a restriction on the freedom to provide services that is in general precluded by EU primary law. That judgment introduced a possibility for EU citizens to obtain a health service that is covered by their public healthcare system in another member state without prior authorization on grounds on the freedom to provide services. However, that freedom is not unconditional. The Court of Justice emphasized in numerous judgments that cross-border health services cannot undermine the stability of national healthcare systems. Because of that, appropriate planning requirements may justify the requirement to obtain prior authorization. Such planning is needed especially with regard to hospital services and also services involving the use of specialist medical equipment. Those judgments had a significant impact on the situation of patients accessing transboundary healthcare. Firstly, patients in the border regions gain the possibility to seek healthcare on the other side of the border that might often be for them a more convenient way to satisfy most basic medical needs. Secondly, the Court of Justice enabled all patients to seek health services of higher quality and better treatment methods in other member states. Finally, the CJEU's case law became very favorable for the patients in terms of reimbursement of costs. The Court of Justice granted them not only full reimbursement, including also the expenses on travel and accommodation, but also, in the judgment in the case of Van Brakel, reimbursement exceeding the costs actually incurred if they are lower than the costs that would be afforded to a person receiving treatment in the home member state. On the other hand, the judicial activity of the Court of Justice created a state of legal uncertainty for both patients and member states. The individuals lacked clear rules and procedures for reimbursement of, in some cases, very, very high costs incurred on the health services in other member states. On the other hand, the member states wanted to stop the judicial activism of the Court of Justice, mainly because they considered it as a threat to the financial stability of national systems. Consequently, the need for the codification of the rules deriving from the CJEU's case law became more and more pressing. Despite that, the adoption of Patients' Rights Directive was a long and complicated process because of the conflicting interests of particular stakeholders. The Commission was focused on strengthening the process of European integration in the field of healthcare and enhancing the protection of patients, whereas the member states within the Council wanted primarily to stop the judicial activism of the Court of Justice and protect the finances of national healthcare systems. Those conflicting interests are demonstrated by the differences between the legislative proposal submitted by the Commission to the European Parliament and the Council and the final version of the Patients' Rights Directive. On the screen, you can now see extracts from the preamble of both documents that illustrate how different is their spirit. The proposal, on the left, widely refers to the Charter of Fundamental Rights, especially its Article 35 and the right of access to healthcare, whereas the directive, on the right, does so only once, with regard to the protection of personal data. Instead, the directive emphasizes that its goal is not to encourage a wide group of patients to access transboundary healthcare. Also, Article 1 of both documents demonstrates the concerns of member states concerning the adoption of the directive. The proposal clearly stated that this legal act applies to cross-border healthcare. Despite that, the member states wanted to strongly emphasize that it won't in any way affect their laws in situations without the cross-border element. So the significant hopes that Patients' Rights Directive will be the second Schengen that would make all the hospitals and health centers available for all EU citizens turned out to be exaggerated. The final version of the directive contains some significant step backwards in comparison with the Commission's proposal and the case law of the Court of Justice. Most importantly, it grants the member states a much wider possibility of requiring prior authorization to seek healthcare in another member state. In the system established by the Patients' Rights Directive, getting prior authorization to seek healthcare abroad is as a rule not required to claim reimbursement of the costs of healthcare obtained in another member state. However, there are numerous exceptions. According to the Commission's proposal, they would concern only hospital care, as the Commission wanted to prohibit any prior authorization in the field of non-hospital care. Unfortunately, the final version of the directive does something opposite. It contains 3 limitation clauses allowing the member states to require prior authorization to seek healthcare in another member state. The first one refers to the planning requirements that are mentioned also in the CJEU's case law and the proposal. But the directive here de facto makes the whole field of hospital care and care requiring the use of highly specialized medical equipment subject to prior authorization. Apart from that, the other 2 exceptions are much more vague and therefore leave member states a significant margin of discretion in their implementation into the national systems. Determination of which treatment presents a risk for the patient of the population is highly discretionary and causes uncertainty about whether the administrative body deciding on the authorization may challenge the decision of the doctor, of the medical specialist, issuing the patient a referral document. Finally, it is questionable how the concerns relating to the quality and safety of the care should be determined. It would be reasonable to require some kind of control directly at the provider in question, which on the other hand seems both organizationally and financially impossible. That once again leaves a wide margin of discretion to national administrative bodies. As a consequence of that wide margin of discretion, the approach of particular member states to transboundary healthcare differs significantly, which leads to legal uncertainty for individuals. The vague exceptions from the directive allowing the states to require prior authorization may be interpreted differently in particular member states. Because of that, in some cases, in-depth legal knowledge might be necessary to assess whether a particular patient will or will not be entitled to the reimbursement from the National Healthcare Fund. That legal uncertainty leads to inequalities on 2 levels. Among member states, the number of patients accessing cross-border healthcare differs tremendously. The state most open to cross-border healthcare is France, which in 2021 received almost 500,000 requests for reimbursement not subjected to prior authorization, which is more than 80% of all requests in the EU. In comparison, Italy received only 140 such requests. Poland, about 25,000. What's worse, the functioning of the described mechanism of reimbursement contributes also to increasing inequalities between the patients in the EU. Only the wealthiest individuals can afford to pay for the service upfront and wait a couple of months for the reimbursement, keeping also in mind the possibility of not getting it. Because of that, there are reasonable doubts about whether the Patients' Rights Directive contributes to the protection of all patients or only those who can afford to make use of their so-called market citizenship. And those doubts are not only of theoretical nature, since they may raise reasonable questions about their compatibility with Article 35 of the Charter of Fundamental Rights. So to conclude, what could be done to eliminate those negative consequences of the currently functioning mechanism? In my opinion, above all, a huge shift is needed in the attitude of member states towards transboundary healthcare. For any amendment to be effective, they need to stop considering cross-border healthcare as a threat to the national systems and start to see the opportunities deriving from it for both patients and national healthcare providers. Such a change in the attitude would allow the member states to improve the user-friendliness of the system of cross-border healthcare and to encourage a larger number of patients to make use of it. To achieve that, the financial risk for patients, discouraging them from accessing cross-border healthcare, needs to be ended. The rules of the reimbursement need to be clear and equal for all the patients, so they can be sure of the amount of costs they will be reimbursed. Finally, the member states, their administrative bodies, and each individual doctor should take action to raise awareness of patients concerning their right to access to transboundary healthcare, since it currently seems to be very, very low. Thank you very much for your attention, and for those of you who would like to read the case law or the doctrine I spoke about, I prepared the references I referred to during the presentation. Thank you very much.